Hey guys, today we're going to talk about retrenchment in Singapore. First things first, there is no automatic right to retrenchment benefits in Singapore. In other words, there is no legal obligation for an employer to pay retrenchment benefits in Singapore. This principle was laid down in the Singapore court case of Loh Seok Wah and American International Assurance. Therefore, by reason of this, all retrenchment benefits paid by an employer is on an ex gratia basis. Section 45 of the Employment Act deals with the payment of retrenchment benefits, but it is a very odd provision because it is phrased in a negative way. What it says is that no employee who has been in continuous service with an employer for less than 2 years shall be entitled to any retrenchment benefit on his dismissal on the ground of redundancy or by reason of any reorganization of the employer's profession, business, or work. So it's phrased in a negative way. It says that if you work less than 2 years, you are not entitled to retrenchment benefits. But if you work more than 2 years, the Employment Act doesn't say whether you are entitled or not and how much you're entitled. That's why it's a very odd provision. So therefore, your retrenchment benefits, should ideally be found in the employment contract or in the company handbook or company policy. Further, the Employment Act does not require the employer to disclose the selection criteria for retrenching its staff. It also does not require the employer to give the employee time to look for a new job or even to give the employee minimum notice. In other words, you can just retrench someone by giving the normal notice provisions under the Employment Act, or if there's a written contract, the termination provisions under the employment contract. The case that I mentioned earlier, Loh Seok Wah and American International Assurance, the court also stated that just because a company paid retrenchment benefits previously does not necessarily mean it has to pay retrenchment benefits to other employees on the same terms. So just because a company used to pay again and again and again retrenchment benefits, for example, 1 year for every 1 month salary for every month work, doesn't mean in a specific case of an employee it has to do the same thing. So, however, industry practice, the norm is that retrenchment benefits of 1 month for every year of service is paid. But that, as I said, there's no obligation for the employee to pay that. It's all ex gratia. This is especially important for employees in senior positions who do not fall under the Employment Act. If you are in a managerial director position, it is always important, to either during the interview or before signing the employment agreement, always ask what are the retrenchment benefits payable. Because of the high salaries of senior management persons, they have more bargaining power to include clauses in the employment agreement relating to retrenchment benefits. Thanks for watching this video on retrenchment.